Excellent. Yes, and thank you for coming out on a Saturday evening or Saturday morning, as the case may be, or lunchtime, wherever you are. As you've just heard, I'm a barrister working in Sydney, and I work in corporate and commercial law. I came to Roman law about 5 years ago when I studied a master's at the University of Oxford in the UK. It was in 2016-17, and I took a course there titled The Roman Law of Delicts, which we'll learn a little bit about tonight. Roman law has been taught at Oxford University for around about 870 years, since about the middle of the 12th century. So there's a deep history there, and you'll be pleased to know that Roman law is alive and well. It is very much studied and discussed in the hallowed halls of Oxford and Cambridge, and indeed other universities. In fact, every law student who undertakes undergraduate law at the University of Oxford has a compulsory first-year subject entitled a Roman Introduction to Private Law. So from the very first moment that students are learning about the law in Oxford University, they're learning it through the Roman eyes, and yes, and it's studied in the master's course there as well. Okay, so you should have two documents that I'll make reference to tonight. The first document is only of 2 pages, and I'll call that the introduction handout. That's a document titled An Introduction to Roman Law with Benjamin Goodyear, and on the top of page 1 you'll see the heading, The Scenario. The scenario is a little scenario that I thought we would use to interrogate a few ideas from Roman law, and we'll spend a bit of time looking at that in the second half of this evening's presentation. And over the page, on page 2 of that introduction handout, you'll see some information, namely a basic chronology and a few bullet points under the heading Sources of Law, which I'll discuss. The other document, which has a picture of Gaius on the front, is titled Additional Materials, and the second page of that has the agenda for this evening, and the third and fourth page contain some material that I'll discuss. I thought that'd be handy so everyone has a copy and they can mark it up or have a look at it in their own time. Okay, so we'll begin with part 1. I thought I'd just start by answering the question, what is the study of Roman law? Now, given the audience that I'm speaking to, I won't need to spend as much time on this question as what I might with other audiences, but yes, what is the study of Roman law? Well, my working definition of the study of Roman law is the study of the laws of ancient Rome with a particular focus on the period 161 AD and 533 AD, to the extent those laws have survived via transmission. And what do I mean by that? We can only study material that we have a copy of, so we are beholden in some senses to the manner in which these laws have been transmitted down through the ages, either copied, reproduced, or patched together through other means. And Roman scholars are quite inventive in the way that they will try to recreate knowledge about the laws of ancient Rome, and information can be gleaned from a number of sources, even from scripts of theatre plays. Latin comedy writers would refer to or have scenes in their plays that would give us information about how the court process worked, how slaves were treated, and so forth. So these lines of transmission can come through any number of ways, and to the extent that these legal texts have survived, we have the benefit of studying and enjoying them. Now, I mentioned two dates, 161 AD and 533 AD. Those dates are important for this reason. In AD 161, a Roman teacher and jurist and scholar by the name of Gaius lived and was producing legal texts, and he wrote a textbook for law students who were studying law in the law schools in the Roman Republican times. And in quite remarkable circumstances, which I'll come to later, we have a copy of around about 85 or 86% of that introductory textbook. So we can still study it. You can buy a copy off the internet today, and that gives us a window into what the laws were at, as I say, around about AD 161. We don't know precisely when the legal textbook was written, but scholars have estimated it was around about 161 AD because of the certain laws that it refers to. Obviously, any laws that were passed after 161 are not going to be able to be referred in that book and so forth. Now, the second date, AD 533, is probably the most important date of all, and that's the date that the Emperor Justinian published his digest and also a number of other works, and that is probably the most famous and enduring legal text from the Roman period, Justinian's Digest. So that Justinian took the throne in 527 AD. He was 36 years of age, and he set about restoring Rome to its former glory in a number of ways, and one way was by commissioning a series of legal texts, the most famous of which is the Digest, and again we have a copy of that has been transmitted down through the ages, and we can study that. Okay, now the Romans, as you would probably know from your involvement in the Roman learnings, the Romans had a very sophisticated array of laws. They had laws on a range of recognisable topics, everything from civil procedure to real property to contracts, the law of marriage, and so on, and right down to the minutiae laws relating to clearing of drains and whether you can use force to prevent a neighbour from coming on your property and collecting acorns that had been had fallen there and so forth. So a whole range of areas and quite sophisticated concepts that, as a practicing barrister in 2021, see strong similarities between the way the Romans dealt with things and the way that we deal with things today. So that's a bit of a flavour of what is the study of Roman law. It's focusing on the Justinian's Digest, a legal text from 533, and also Gaius's Institutes, which is a textbook for law students in 161 AD. And that gives us a window into those two times of what the laws were, and we can make comparisons. We can see how law reformed or evolved over that period. Okay, now I'd like to move to make a few comments on the chronology. So if you could take up the introduction handout, that's the 2-page document, and on the second page of that you'll see a brief chronology. I've set out there the main constitutional orders. What do I mean by that? When I refer to constitution, I'm talking about how power was distributed in society, how decisions were made, where was power stored. As we know today, there's a whole range of constitutional orders. We can have monarchies, constitutional monarchies, absolute monarchies, dictatorships, republics, and so forth. And as you're probably familiar with, the ancient Rome went through various machinations from a monarchy. in circa middle of the 8th century BC, a series of kings, and that moved into a republic around about 510 BC. There was a revolt of sorts against the tyrannical use of power, and the monarchy was toppled and replaced with the republic. The republic is probably the most interesting constitutional order of ancient Rome because of the tripartite nature of it. So we had three main elements. We had the magistrates, who were the inheritors of royal power. So when the line of kings were toppled, the monarchy was no more. It's called imperium. That kingly power was invested in, needed to go somewhere, and it found a home in a range of magistrates. The highest being the consuls, and various other magistrates responsible for various other areas of administration of law. The second element of the Roman Republic was the Senate, and you'll no doubt be familiar with scenes from the movies and so forth, seeing senators stand around and debating law proposals. And the third element of the Republican Constitution was popular assemblies, popular in the sense of constituted of the populace, of the citizens. I won't spend too much time going into that, but that's the Roman Republic endured for some 500 years and then gave way to the empire. On the chronology, there's one particular area that I'd like you to note. It's just under the heading Empire Principate, and it's the period AD 120 to AD 225, and that's referred to as the High Classical period. It's really the most fertile period for Roman law for two reasons. One, that's a period when many of the great renowned jurists were alive and producing works, Gaius being one, Papinian, Ulpian, Paul, Julian, the list goes on. And coupled with that, there was also a form of civil procedure, the way that you sue someone, that was more flexible, and that allowed for a greater development of the law. So we'll look at what the form of civil procedure was tonight, and we'll also look at some of the writings from those jurists. But that period, the High Classical period, is the period that we'll be thinking about tonight when we look at the scenario. You'll note from the scenario on page 1 of the introduction handout that it's set in the year AD 120. That was for a deliberate reason, to just remind us of the importance of the High Classical period. Okay, now moving down through the chronology, we see the empire and Justinian taking the throne in AD 527, and he commissioned a range of works, the Digest being the most important. He also prepared his own version of an introductory textbook for law students, and that's also called the Institutes. And then in AD 565, Justinian dies. That period from 753 BC all the way through to the death of Justinian is referred to as the first life of Roman law. That was Roman law as it was, if you will, living and breathing, providing guidance to the ancient Romans. There's a second life of Roman law which kicks off in around about the 11th and 12th and 13th century, and that's a revival of the Roman teachings, which is picked up in the University of Bologna and spread through the civilian law countries and really carries it through to today. So I'm not a scholar of that second life of Roman law. My main focus is on the first life of Roman law. All right, with those introductory remarks about the chronology, in mind, let us now move to, I'd like to say something in more detail about Justinian's Digest, because if there's one Roman legal text of which you should all be aware, and which we will look at later in the presentation, it is Justinian's Digest. What was it? Well, one way of thinking about Justinian's Digest is just simply thinking of it as a legal encyclopedia. It was almost, but not quite, a one-stop shop for all the law of the Roman Empire in the early 6th century. Now, there are some exceptions to that, but that's a good working definition in your mind. It was a legal encyclopedia. It had laws on the full range of topics, and we'll have a look at some of those shortly. To explain a bit more about what the Digest is and how it was made, however, it's quite interesting how it was made. I need to discuss sources of law. Where do we find the law in ancient Rome? Where does it come from? Then I'll mention again Justinian's ascension to the throne, and then I'll talk about the compilation of the Digest, how it was actually put together. I need to talk about the sources of law to explain the way the Digest was put together. So, sources of law, what am I talking about there? Well, today, sources of law, we find law in Acts of Parliament, State Parliament, Federal Parliament, delegated legislation, conventions. We have law from decisions of judges and so forth. When describing the sources of law in ancient Rome, normally 3 categories are used, and those categories appear just underneath the chronology on the 2nd page of that introduction handout. So if you have a look at those sources of law, you'll see the 3 main categories. The first category is statutes. Second is edicts of the magistrates. And the third is what's called interpretatio of the jurists, or interpretations of the jurists. And that's probably the most interesting, and is what fed into the Digest in a manner I'll explain. So let's learn a bit about the various sources of law. As I say, the first category that's often referred to is known as statutes. And statutes could come in various forms. The first on the introductory handout there is lex, and they are enactments of the comitia. So in a very broad outline, the process of lawmaking in the Republican period was a debate amongst the senators in the Senate about a proposal. A magistrate would then propose the law to the popular assemblies, and the assemblies would vote yea or nay on the particular law. If the law was passed, it would take a name, and one of the particular lexes that we'll look at is the Lex Aquilia, and Aquilia. The Lex Aquilia means law of Aquilia. So Aquilia was the name of the magistrate who proposed the law. So we have statutes, not too dissimilar to statutes of today. Obviously, we don't all go down and vote on laws that are passed, but members of Parliament propose bills, and they're debated and they're voted upon by us indirectly through representative democracy. We vote people in to vote on our behalf, and for the production of laws in the form of statutes. In the Roman Republic, the populace had a direct involvement. One particular key statute is known as the 12 Tables, and that was published around about 451 BC. That was a collection of 12 bronze tablets that was set up in the marketplace, publishing the law so it could be known to all, and some of the later law derives directly from the 12 tables, so a very important foundational statute in Roman law. The third hollow bullet point that I have on the introduction sheet is Senatus Consulta. There's a bit of debate about this, that they are resolutions of the Senate, and scholars will debate about the extent to which they had the force of law. It seems at least during some periods, it's said by around the 2nd century AD, they in effect had the force of law. So another source of law. And the fourth form of statute I have there is Constitutiones, and they are pronouncements of the emperor, not to be confused with constitutions in the sense of the governing structure of a society. These are discrete pronouncements of the emperor, and they came in 4 main forms: edicta, mandata, decreta, and rescripta. Edicta were just official orders or pronouncements or proclamations, could be a range of forms. One quite famous edicta is an edict of the early 3rd century, and Antoniniana pronounced an edict that gave Roman citizenship to most of the free inhabitants of the empire. Now, you might think that was a quite kind thing to do, to confer the joys of Roman citizenship on all, but the main reason was for taxes. The more citizens you have, the more people you can levy taxes from. So that's a famous edicta. Mandata were administrative in instructions to officials. They're not quite as exciting as the other form of pronouncements. Decreta are quite interesting. Occasionally the emperor would sit as a trial judge or an appellate judge and make decrees on particular legal cases. And rescripta are probably my favourite. Rescripta involved petitions being written by citizens or public bodies who needed an answer on a discrete issue, and they could write a petition to the emperor, who would pronounce the answer in effect, and the emperor, by virtue of his office, would create law through that rescripta. Okay, so they all fall under the heading of statutes. Now, the second broad category of sources of law are what is known as edicts of the praetor. You might recall I mentioned after the monarchy came the republic, and the imperium, the kingly power, found its home in the magistrates. The consuls couldn't do everything, and various other magistracies cropped up. The magistracy, or the magistrate in charge of the administration of civil law, was the praetor. So the praetor you can think of as the chief administrator of the civil law. Now, the praetor took office only for 1 year, and each year a new praetor was installed. At the beginning of each year, the praetor, who we'll learn a bit more about in due course, published what is called the edict, the capital E edict, and it was a series of statements of policy where the praetor was setting out the circumstances in which he would grant particular remedies you could think of it as a collection of recognised situations in which a private citizen could come to the courts and ask for relief. We'll see what was in the edict a little bit later this evening, but by the Praetor saying these are the situations in which I will grant particular remedies, could be a remedy for, I don't know, someone may have defrauded someone, or there may be damage to particular business interests or what have you. But by the Praetor setting that edict at the beginning of each year, it was a way in which the law could reform and develop over time. Now, the great body of the edict carried over year to year, but each Praetor could put his particular bent or inclinations into the edict. Now, the third and final category of source of law, I think, is the most interesting, and this is the interpretatio of the Roman jurists. So, who were the Roman jurists? The Roman jurists were men from leading families who contributed to public life by developing their knowledge of law and offering it as a service to other Roman citizens and also public officials. You could think about it as a very, in modern day terms, perhaps a very extremely experienced barrister, a Queen's Counsel, who is, as a way of giving back to society, is offering his or her services for free, and also advising law reform bodies and so on. So it's a broad, the Roman jurist is a broad term for scholars, writers, teachers and advisors. And they did a number of things. They advised the Praetor in the Praetor developing his edict at the beginning of each year. They advised judges in deciding cases, and they advised parties in drawing legal documents, anything from a will to a business negotiation contract and so forth. And most importantly, for present purposes, they wrote everything from textbooks to monographs to commentaries on other people's works and so forth. So an enormously rich body of writings was produced by the Roman jurists, and that's important for a moment, for a reason I'll come to shortly. They did not, however, appear in court. So that was the realm of the advocate. The advocate was a specialised role. Perhaps one of the most famous advocates of all time is Cicero, but the Roman jurists were not somewhat curiously, were not actually advocates in court. The advocate was skilled in the art of rhetoric and persuasion. So the great jurists, we saw a few of their names listed on the chronology: Gaius, Opinian, Ulpian and Paul. Others, Modestinus, Sabinus, and so forth. So some great names there for a pet dog or a pet fish next time you're looking for a name. Okay, now what we're doing at the moment is we're working towards an understanding of Justinian's Digest, and I've taken you on a bit of a divergence, but I needed to lay this groundwork and particularly introduce you to the Roman jurists for a reason. And the reason is this. So, as I say, Justinian took the throne in AD 527. Interesting fun fact, Justinian was adopted. So he took the throne, and when he took the throne, Rome, where Rome is today, was no longer a part of the Roman Empire. Rome was sacked by the Gauls in around early 5th century, 410 AD, and Justinian took the throne, and he set about a number of measures to restore Rome to its former glory. Now, there were various military engagements to recover some of the lost territories, but for my purposes, or for tonight's purposes, what we're focused on is his enormous endeavour, his project of law reform and consolidation. So Justinian takes the throne and wants to emphasise the brilliance of the Roman jurists who have come before him. And what he does is he commissions a number of works, the main one being the Digest. But before we get to that, he had to take a number of preparatory steps. There was a bit of sweeping up or cleaning up to do first. The first thing he did was issue a new collection of constitutiones, the edicta, rescripta, and so forth. So we won't spend time discussing that. Another thing he did was issue what's called the 50 decisions. The jurists who had been writing various, as I say, textbooks, commentaries, they're commenting on each other's work, they're commenting on the edict. Various controversies had developed, thorny points of law where jurists couldn't agree on what particular outcome or the proper state of law should be. So Justinian, using his power as emperor, resolved 50 of these key decisions. So with this cleaning up work done, we have some new pronouncements of the emperor, we have the 50 decisions. Then the stage was set for the commissioning of the Digest. What Justinian did was he assembled a group of 16 men. The leader was a man called Tribonian. Tribonian was what we might call the chief minister of justice, and there were 11 legal practitioners, lawyers, and then also 4 law professors from the law schools. What they did was collate around about 2,000 they collated around about 2,000 books of previous jurists' works. Now, a book actually in Roman law scholarship is not is actually a unit of measurement. So just to give you an example, this, which is what we would call a book, this is a thickness of around about 3 or 4 books in ancient Roman law terms. So this team of 16 men collated 2,000 books equivalent of various jurists' writings on a whole range of topics, and they worked through those books and took out the best bits of what they thought should be, under Justinian's guidance, the law restated in 533 AD. So let's just pick an example. Let's say there's the Roman law of theft, the law dealing with someone interfering with someone else's property. So the team that Justinian had assembled collated what, for example, Gaius had said on theft, Papinian had said on theft, Ulpian had said on theft, Julian had said on theft, and then selected bits from each classical jurist's works and in effect cut and paste them and collated a new statement of what the law should be on the law of theft. Now here's the fascinating thing. when the jurists did this under Justinian's, when the commissioners under Tribonian performed this task, they kept the name and the work of the original jurist. So they didn't just lift the previous classical jurist's work and adopt it as their own. No, they had respect for and paid due regard to the original classical jurist, and they cited the original jurist in the digest. So this might be a good time to just have a look at what the digest, what an excerpt of the digest looks like. So if I can invite you to take up the second document, it's called Additional Materials, and it has a picture of Gaius on the front. And then if you turn to the very back page, you'll see the heading Excerpt from Justinian's Digest. Now this is obviously an English translation, the original being in Latin and some Greek. The digest, the final form of the digest was 50 chapters, or they're called books, 50 books, and then each book was divided into fragments, and they have further been divided into books, titles, fragments and sections. So what we're seeing here, there's a page, you can see towards the top, you'll see book 47, thefts. So this is a book 47 dealing with a broader category of delicts, which I'll explain shortly, and then about a third way down the page you'll see the number 2 and the word thefts. So we're in book 47, title 2. The number 2 is the title, and this is what the digest teaches us about the law of thefts. Now just under the heading thefts you'll see a number 1 and the word Paul, edict, book 39. A bit further down you'll see the number 2 and the name Gaius, edict, book 13, and then 3, Ulpian, and then 4, Paul, and then 5, Ulpian. So this gives us a good visual of what I was describing. This is a section on thefts in the digest, and it's comprised of snippets of previous classical jurists' works. So the first fragment, number 1, is an excerpt from Paul, and then fragment 2 is something that Gaius wrote about thefts. Fragment 3 is something that Ulpian wrote, and so forth. After the name of each classical jurist, you'll see some words in italics. So let's head back to fragment 1, Paul, edict, book 39. What that tells us is, what follows is an excerpt from what Paul wrote when Paul himself was writing about the edict. You'll recall that the edict was the document that was published each year by the praetor at the beginning of his year in office. And as I mentioned earlier, the jurists would not only write textbooks and monographs, but they would also comment on other legal documents. So here we see Paul having commented on the edict. Paul himself wrote many, many books, and this is an excerpt from his book 39 on the edict. So there's quite a few layers going on. There's quite a bit of information to be unravelled. And the other point which needs to be made is, what we see is a dual temporal layer. What do I mean by that? The digest was compiled in 533 AD, and Justinian, through his commissioned men, Tribonian and the team of 16, they obviously had some editorial choice. They could choose which bits and pieces they would snippet out of the classical jurists' works. And in that sense, the way that the law is pasted together and finally printed as the digest gives us an idea of the law in 533 AD. But because each snippet has the name of the original author, and we know when they lived, so these gentlemen lived in and around the High Classical period, the 2nd and 3rd century, we can also see what the law was in their time. So we have this dual, that's why I say this dual temporal layer. The reference to the original jurist is called the inscriptio. That's what we might think of as the citation. Yeah, so let's just take a little sidetrack and have a bit of a look at the law of theft. So Paul, on the Edict, Book 39, he tells us a bit about the etymology. Theft, says Labeo, derives its name from the dark. What happens furtively? On the 5th line of Paul's segment, you'll see another number 1. That's called the section. So from broadest to narrowest, we have book, title, fragment, section. And section 1 says, hence mere theftus intent does not make a thief. So if you had a question, if someone said to me, hey Ben, can I be guilty of theft just by thinking about stealing something? And I was a legal practitioner in 535 AD, I would say, hang on, let me just grab my copy of the digest off the shelf. I would flick through to book 47, title 2, fragment 1, section 1, and I would say, well, no, mere theftus intent does not make a thief. And the Justinian's Digest really was there for legal practitioners as well. So it was designed to be used by the lawyers of the day. What else do we see? Gaius in fragment 2. Gaius, he was writing on the edict. In Gaius's book 13 on the edict, he says, theft is of 2 kinds. Either it is manifest or it is not manifest. And then Ulpian tells us what that means. Ulpian is writing on Sabinus's works. He was another jurist. A thief is manifest, that is one caught in the act of theft. So, just discussing a little bit about the law of theft, there were 2 kinds, manifest and non-manifest. If, say, you were asleep and you heard someone rumbling downstairs and you woke up and saw a thief with your golden dish running out of the door, and you caught him before he left the house, you could bring an action for manifest theft against him because you've caught him in the act. And what's the difference? Well, the penalties were greater. The amount of money that you could extract from the thief was greater for manifest theft. So a bit of a sidetrack there, but I just wanted you to have a visual of what does the digest look like. And as I said, it was put together in a rather unique manner in the sense of a collection of cut and paste excerpts from previous jurists' works. I think the Inscriptio is an honourable device, and it also tells you something about the mindset of Justinian. He in restoring Rome to its former glory, he really was looking to the past and bringing this greatness into the light, and not just plagiarising it as his own, as he could have done if he wanted to. The digest has been described as obsessively unoriginal, and that's a reference to these Inscriptio. All up, there were 38 or 39 authors who are quoted in the digest. Around about a third comes from one jurist alone, and his name is Ulpian, who you'll see on the on the excerpt of the digest. So around about a third come from Ulpian, and about a sixth comes from Paul. So the digest was promulgated on the 16th of December in 533 AD, and it came into force 14 days later. Now, Justinian forbade recourse to any other legal texts. So there was a process of tidying up with the code and the 50 decisions. There was a taking of all the best bits from previous classical jurists' works, and there was a creation of the digest, and as I mentioned earlier, Justinian really wanted to be a one-stop shop, and for it to be the most authoritative voice and guide to practitioners. It's not an overly large document, so you can buy a copy today, and it will be about it will be 4 volumes of around about this thickness. So not enormous, but yeah. So the reason why I mention the fact that Justinian forbade recourse to other texts is because some of you may be sitting there with ears may have pricked up, and you may be thinking, well, how do we have access to Gaius's institutes? Right at the outset of the presentation, when I was answering the question, what is the study of Roman law, I said it's the study of Roman law around about 161 AD and 533 AD. Now, AD 533, we have Justinian's Digest. How do we have a copy of Gaius's institutes? Recalling institutes just means teaching tool, so that was Gaius's textbook for law students in the 2nd century. Now, this is fascinating. In 1816, an academic was working in a library in Verona and noticed something on a palimpsest. A palimpsest, as I understand it, is a piece of writing paper that was reused. I think it was either some form of scraping away or some layering over of other texts. And the scholar noticed some writing that was still visible underneath the present work. And by carefully either using various chemicals or scraping away the present text, the layer underneath was uncovered, and it turned out to be an almost complete, around about 85 or 86% copy of Gaius's Institutes. And this was just remarkable because, as I say, Justinian had forbade recourse to all other texts. There was no need to keep them anymore, and they just fell into disuse. So this uncovering of Gaius's Institutes was a revelation for Roman legal scholars for a number of reasons. One, it gave us, not only gave us insight directly into what Gaius's institutes were in the 2nd century, but it also gave us insight into how faithful Justinian was and his compilers were when they quoted from Gaius's Institutes. So where we see Gaius's Institutes quoted in the digest, we now have another line of transmission coming directly from Gaius, and we can see whether Justinian's compilers were faithful or not. And this all is taken to a whole new level when we look at Justinian's Institutes. So Justinian commissioned the digest. That was a bit unwieldy for law students, so Justinian also commissioned Justinian's Institutes, so a legal textbook for law students in the 6th century. And modern day Roman scholars have compared Justinian's Institutes to Gaius's Institutes, and in fact, when you buy a copy of Gaius's Institutes, I don't have my copy here, but the text will be printed, and where Gaius's Institutes have been directly copied verbatim by Justinian into Justinian's Institutes, the text will actually have the font in bold. So when you're reading the text, you can see what text was carried over to Justinian's Institutes, and sometimes it's very large slabs. Yes, so there we have Justinian's Digest, collection of previous jurists' works, Justinian's Institutes, and he also commissioned an updated code, a collection of Constitutiones, and there's also, he continued to make further pronouncements, and those collection of further pronouncements are called the Novels. You may see that the term Corpus Juris Civilis. Corpus Juris Civilis is a modern term for the collection of works, the digest, the institutes, the new code, and the novels. So just be aware of that, that label. Okay, well, that has, in immaculate timing, I see the time is 9:30, that has brought me to the end of what I wanted to discuss in the first half of this evening. In the second half, armed with that introductory background, we'll start by reading through the scenario, and then we'll launch into some of the detail of Roman law. I'm conscious of the fact that there's a balance to be struck in an introductory session on Roman law. There needs to be some orientation with the basic chronology, sources of law, and what is the digest and so forth. But a lot of the enjoyment comes from looking at the detail. So in the second half, we'll be looking at some juicy detail of particular aspects of Roman law.
Perfect, and right, very good. And for part two, handing back over to you, Mr. Goodyear.
Thank you very much, and thank you for coming back. Nice to see you all still here. And as I say, we're going to be having a look at some of the detail of the particular aspects of Roman law, which I think should make for an interesting second half. So if I can invite you to pick up the introduction handout, it's a 2-page document with the scenario on page 1. And let's just refresh ourselves on the scenario. The year is AD 120, the cusp of the High Classical period. You, Marcus, are a wealthy land and slave owner. You're a busy man and you cannot be everywhere at once. You entrust Sticus, one of your most loyal slaves, to put part of your funds to work by running a stall at the local market. It proves a profitable venture. Sticus is an entrepreneurial slave who is eager to curry favour with you in the hope of earning his freedom. But one morning there is an accident. Carting his wares to the marketplace in the dim light of morning, Sticus runs over and kills Lucius. As it so happens, Lucius too was a slave, a most talented lyre player. Marcellus, who was the owner of Lucius, is furious. You know Marcellus to be a most litigious type, and you expect this matter will end up in court. And there we revert back to the italicized heading at the top of the page. Help! My slave has committed a delict. What should I do? Now, hopefully in an hour, you will have at least 2 answers to that. So what I propose to do is step through some discrete legal topics, and then at the end of part 2 of the remaining time, we'll go back and we'll look at that scenario again, and hopefully we'll be able to see it in a bit of a different light. Okay, I'm going to start with the Roman family structure. This is a bit of a segue into explaining the role of slaves, but the treatment of slaves and what are called children in power was not dissimilar, so I thought we might as well learn about both at once. The Roman family was the legal unit, and it took in importance in a number of ways. So Roman family law was based on the fundamental concept that each family had a pater familias, who was the head of the household. I should say the second document, the additional materials, has a glossary in it. Just after the agenda, the third page is a glossary. So if you are hearing some of these terms and you just like to see what the spelling and what it looks like on the page, that was a reason for me coming up with this distributing this glossary. I always like seeing the word with my own eyes. So pater familias, head of the household, and the head of the household was chosen as the eldest living male ancestor. So you might think about your own family, extended family tree. For me, I have my parents both still alive. My father's father, as in my grandfather, is deceased. So my father is the pater familias of my family unit. Let's take an example of a son. Let's keep it quite simple. A son, a father, and a grandfather, and just forget about everyone else for the time being. The son and the father both have the same pater familias, who is the grandfather. When the grandfather dies, then the next in line, the father, becomes the pater familias of his son and any children that his son may have had by that stage. Everyone who was in the power of a common pater familias was known as an agnate. So my agnates are the people who share a common pater familias. Now the best way I've found the best way that I've had this described to me to really understand what's going on is this. The English system of surnames is agnatic, except for the rule that a wife takes her husband's name. So let's imagine everyone in your extended family follows the normal English system of taking their father's surname, and let's just tweak it by having the wife of anyone who marries always keep her maiden name. So if you drew a family tree of that kind, every child takes his or her father's name, and when a couple marry, I appreciate I'm using stereotypes here, but for the purpose of the illustration I need to, when a man marries a woman, keep the woman having her maiden name, and then if you looked at that family tree, you would see a particular surname flowing all the way down, and that would be the agnatic line. So that might be something you can try in your own time, figure out who your agnates are. Now that was important because the pater familias had power, known as potestas, over everyone underneath him, and they were known as filia familias and filius familia, the children in power. So let's have a look at some of the consequences of potestas. Just before I move on, if you had no older male living relatives, so the example I gave of a child, a father and a grandfather, if the grandfather died and then the father died the very next day, the child would be the pater familias, no matter how young the child was. Now, there's a kicker to that, where a child who was not of age could have a tutor appointed, someone to look after his affairs. But yes, the eldest living male ancestor was the paterfamilias. So some of the key consequences of the paterfamilias having potestas over the agnatic line. There were rights over the person, which I'll explain, rights over property, which I'll explain. It had an effect on the ability for children in power to contract, and we'll also look at the concept of emancipation. So in terms of rights over the person, in early law, the paterfamilias had what was called the power of exposure. If a child was born and the paterfamilias was not inclined to raise it, could literally expose the child and abandon it. And even if the child was not exposed or abandoned, the paterfamilias had the power of life and death over those in his power, in his potestas. So if they displeased him, he could kill them, or also sell them into slavery. Over time, however, and as I mentioned in the introduction handout, when we talk about Roman law, we're talking about a period of 1300 years, from the middle of the 8th century BC, the beginning of the monarchy, through to the middle of the 6th century. Over time, and indeed by the time Justinian took the throne, these powers were curtailed and were less barbaric, and became, in respect of the power over children in power, became one of reasonable, it's called reasonable chastisement. Now, we can debate what that means, but it was no longer the power of life or death. But in early law, the potestas, the power of the paterfamilias, was extreme. Rights over property. Children in power, so when I'm using the phrase children in power, I'm talking about those children lower down the family tree who have the paterfamilias at the top. Children in power could not own property. So if you gifted something to a child in power, or the child in power acquired something, either by finders keepers or whatever, someone conveyed property to it, the property would vest in the paterfamilias. Again, that changed over time. The Emperor Augustus, as a way to encourage recruitment into the army, allowed children in power to keep property. It's called the peculium castrense. So property acquired during military service could be kept by children in power, and there were other exceptions. But the starting point is that, generally speaking, children could not own property. Everything vested in the paterfamilias. Contracts also could it's quite curious. Children in power could, in effect, enter into contracts, but on behalf of the paterfamilias, but only the benefits would be conferred upon the paterfamilias. The paterfamilias would not be bound by any liabilities in respect of the contract. So plainly, it was not a favourable proposition to be entering into contracts with children in power. You really wanted to contract with the paterfamilias. And finally, I mentioned the concept of emancipation. Emancipation was the formal release of a child in power. A child in power under the potestas of his paterfamilias was known as being alieni juris, alien, another, juris, meaning right or law. So alieni juris is a way of saying someone is under the rights of another. Once a child in power was freed, they were described as being sui juris, under the power of no one else. Now, emancipation, the freeing of a child in power, was not always a positive event. You might think, well, I would like to be emancipated. I don't want to be under the potestas of my paterfamilias. However, along with emancipation often came the loss of the right to inheritance. So emancipation could be, the threat of emancipation could be a form of behavioural control, and emancipation could be a form of punishment. Now, how is emancipation effected? There was a rule from the 12 tables. You'll remember the 12 tables from part 1, the statute that was published in the marketplace in 451 BC. A rule from the 12 tables that said selling a son 3 times into slavery would release the son entirely, including from potestas. So in early law, it was a bit of a cumbersome process. If I wanted to emancipate my son, I would round up a buddy and say, look, I'm going to sell my son to you into bondage. Would you please let him go? And the 2 colluders would get together. The son would be sold and then released. Upon the first release, he would enter back into the potestas of his paterfamilias, would be sold again and released, and then on the 3rd time he would be released entirely. That process was streamlined in later law and under Justinian. Now, what we're doing is trying to inquire and analyse this scenario that we looked at the outset, and I've been telling you about the paterfamilias and the potestas over children in power. And the reason is so now we can neatly segue into slaves in Roman society. The treatment of slaves vis-a-vis their masters was not too dissimilar to the treatment of children in power vis-a-vis paterfamilias. Slaves were worse off, though. Before I get into some of that detail, I think it's important to make a few overarching observations. The treatment of slaves varied quite significantly from period to period, especially when Rome was expanding rapidly overseas and wars of conquest were leading to captures of a great number of slaves. As you might expect, the treatment of slaves deteriorated because they were cheap and available in large numbers. And the other thing we should all be aware of is that, yes, slaves performed menial tasks, but not only. We shouldn't just visualise a slave in a loincloth with some tool hacking away at some dry, dusty cliff. Slaves could be anything from business managers, entrepreneurs, musicians, teachers, doctors, accountants, and so forth. And with the time that they spent in people's lives and even looking after children, they could become quite almost like a part of the family. And in some circumstances, if you are a slave in the power of a kindly master, you may actually be better off and envied by citizens who were free but poor. So slaves came from worked in all forms and came from all walks of life. Now, I was talking about the similarities between children in power, or I was alluding to the similarities between children in power and paterfamilias and slaves vis-a-vis masters. Of course, slaves were subject to the power of life and death by their master. Again, we did see some amelioration of that over time, and slaves could not be arbitrarily exterminated. Again, that's a process of law reform that we saw. But the starting point is that they were not really the holders of any rights. They were legal property themselves. They could not own property, and anything gifted to a slave would vest in the master. You might be thinking, why on earth would you give something to a slave if you knew that it was going to vest in the master? Well, you might make a gift, you might leave a legacy, you might have a will, and you leave something to person X, who may at that point be a free person, and by the time you've died or by the time the gift is made, they may have entered into slavery in any number of ways. And a similar position with contracts. Slaves could contract on behalf of the master, but only benefits would confer on on the master, not liabilities. There were exceptions to this, but that was the starting point. Now, with children in power, the concept of emancipation was the process by which a child in power was freed, and for slaves it was known as manumission. Freeing a slave via the process of manumission. A slave once freed was known as a freed man. Contrast that with a person who was never a slave is a free man. So the difference between a free man and a freed man. A freed man is a person who is free once a slave. A free man is a person who's free and never a slave. Okay, the next topic I'd like to discuss is the peculium. The peculium is very interesting, and I must confess I have not spent as much time studying it as I would like, because it really is the most rather intriguing concept. So let's recall, as we've learnt, slaves cannot own property. They were property. This was not an ideal way to have a prospering economy, when the only person who could enter into contracts and own property and deal with other people was a paterfamilias. As the scenario alludes to, you, Marcus, are a wealthy land and slave owner. You're a busy man. You can't be everywhere at once. Roman law had a concept of the peculium, and it applied both to children in power who couldn't own property themselves, and also slaves who couldn't own property themselves. Masters and paterfamilias could allow, a master could allow a slave to use an asset or a collection of assets as working capital. It could be a fund of money. It could be an establishment like a stall at a market from our scenario. Or it could even be another collection of, a peculium could be another collection of slaves. So a slave could be appointed a marshal of other slaves. Now, strictly speaking, the peculium in law was always owned by the master, but in custom and practice, what we understand is that it's still, as I say, by custom, was virtually treated as being owned by the slave. So you could send the slave down to the market with a fund and some denarii and some fresh bread and set up a stall, and the slave could engage in transactions on your behalf and make money for you. The word peculium comes from picus, which means cattle. So the original peculium was probably a flock of sheep or a cattle of some description. Interestingly, that word picus, we see the etymology carrying through even to today to words like pecuniary penalty, money penalty. Yes, so a curious concept, not only because there seems to be a bit of intellectual dishonesty going on, or we say, well, hang on, I thought a slave couldn't own anything. What's he doing when he's down there with someone else's property, with the master's property? And also, even more bizarrely, is, I think this is very bizarre, but the textbooks tell us that a slave could build up his peculium and buy his own freedom. Now, at that stage, I don't know why the master is not just saying, well, hang on, rack off, this is all my money to start with. I think what is happening there is we are seeing customs develop to incentivize slaves to be loyal and faithful, and I would probably do the same thing if I had a whole suite of slaves. I would want to incentivize them, if you had a slave who knew that he was never going to ever be free, well, you'd constantly be wanting to watch your back. I'll say something about that shortly, but this seems to be a way of incentivising slaves to be loyal and faithful, offering them some hope of eventual manumission. The point I was just reminded of, I'm not sure what period during Roman history this applied, but at least at some point, my understanding is that if a slave killed his master, then all of the slaves were killed. So this was, what we've just seen is a carrot, namely offering a slave the opportunity to build up a peculium and buy his freedom. And now we see a big whopping stick. We see a major disincentive to anyone. A very smart device actually, because if you have, well, as one story is told, a slave owner with 400 slaves was killed by a slave, and all 400 slaves were put to death. Now, obviously, it didn't work too well in that scenario, but what the idea was if you had a rogue slave who, say you had 100 slaves and you had a rogue slave who was devising some mischievous plan to stick a knife in your back, you hopefully had 99 slaves who were saying, mate, don't bloody do that, you moron, otherwise we're all going to cop it. Yes. Okay, so putting slaves to good use via the peculium. Okay, so let's just duck back to our scenario and have another look at that. We're on the cusp of the High Classical period. We're a slave owner. We can't be everyone at once, so yes, we entrust Sticus, one of our loyal slaves, to put part of our funds to work. So now we know when we read those words, we're talking about a peculium. So Sticus is taking some of our assets involved in the store, peculium, and he's working up that fund, as the first paragraph finishes, to curry favour with you in the hope of earning his freedom. So either he might be hoping just to be manumitted or perhaps buying his freedom. So that's what's going on there. All right. It's going to take a slight diversion because I think it's quite interesting. I've mentioned in the scenario that we're a wealthy landowner, and not quite essential, but I thought I'd drop that in there so I could segue into the process of how to transfer land, which I find quite interesting. There were various classifications of property in Roman law. There was a division of public property versus private property. So public property was anything from public roads, aqueducts, air, and so forth, bridges. Private property was property capable of private ownership, anything from land, books, cart, horse, etc. Other divisions applied: movable versus immovable property, corporal versus incorporeal property. That's a division between tangible property, things you can touch, smell and grab, and intangible property. An example of intangible property today would be something like an intellectual property right, but the Romans also had intangible or incorporeal property rights, which I'll give some examples of shortly. Another division, and the most important division for present purposes, is a division between res mancipi and res nec mancipi. Res mancipi was the name given to 4 types of property: slaves, beasts of draught or burden, so animals that will carry loads or pull equipment, land in Italy, and the 4th, slightly obscure one, rustic private servitudes. I'll just explain what they are. A servitude, the easiest way is probably to start with an example. An example of a servitude is an easement. So you might have two blocks of land, X and Y. Block X might be landlocked, or the way that you can most easily access a public road is via block Y. Block X can have an easement over a right of way over block Y, allowing whoever is owning block X to walk over or drive a cart and horse over block Y. It's called a servitude because the block Y is serving block X. It's called the servient tenement is block Y. It's serving block X. Now, the servitude is a good example of a Roman incorporeal property right. You can't see, taste, stick your mouth around or smell a right of way, but it is a property right. It can be bought, it can be sold, and it can be transferred. Another example is right to channel water across another's land. Okay, so rustic pridal servitudes. That's an explanation of servitude. The descriptor pridial means attaching to land. You could also have personal servitudes. One that gets a lot of airplay in the Roman text is what's called a usus fructus, I think it is. It's a exquisite little property right that allowed someone to take the fruit, which is where the name comes from, usus fructus, the use of the fruit. So I might have a large crop of fruit, and I might be old and lazy, and my next door neighbour might say, look, can I have access to that and take the fruit? I might grant my neighbour, for a fee, a usufruct. And that's a personal servitude because it's able to be used only by that particular person. Contrast that with a pridial servitude which attaches to the land at block X. Whoever has block X can use the servitude. Yes, and the further descriptor rustic is to contrast with urban servitude. So not servitudes within the city. We're talking about related to agriculture and farming and so forth. Now, why these four pieces of property, you might be thinking? What was so special about slaves, beasts of draft and burden, land in Italy, and rustic pridal servitudes? Good question. They are not necessarily the most valuable assets. We don't see gold or jewels and so forth. But it's thought that these were the four pieces of property that were most useful and essential in early Roman society in terms of the means of production in a peasant economy. So that seems to be the link between all of them for an agricultural society who's producing from the land. You can now see the importance of these. Beasts of draft and burden, indeed. Land in Italy, indeed. Slaves for the manual labour. And that gives us importance to these. You might be thinking, what's so important about the right of access or the right to channel water across someone else's land? Well, in that context, you can well see the importance. All right. So we've learned about the category res mancipi. Now I want to return to the land in particular. How could you transfer land? So if I had some land and I wanted to transfer it to someone for a fee, it could only be transferred by a particular mode of transfer called mancipatio. And let's either mancipatio or another form called cessio in iure, but I'm not going to spend any time on that. I just want to talk about mancipatio. Just actually, I'll ask that question at the end, but here's what the procedure was. So you would require the presence of the transferor, the vendor, the presence of the transferee, the buyer, the property to be transferred, and I'll say a bit more about that shortly, at least 5 witnesses, a person holding a pair of scales who was called a libripens, and the witnesses and the libripens had to be Roman citizens of full age. And the process was the buyer grasped the property to be sold. I'll say something about that shortly. The buyer verbally asserted his ownership of the property using a set form of words, and then struck the scales with a piece of bronze, which he then handed to the vendor. As for the grasping of the property, you might think, well, how do you grasp a piece of land in your hand, or how do you grasp a herd of cattle? For transferring land, just grabbing a sod of earth was sufficient, and for a herd of animals, a particular representative animal was sufficient. The striking of the bronze against the scales may in early times have been the purchase price, but I think over time just became symbolic. But we should ask ourselves, this is all very flowery and would be fun to see, but why bother? Why do we have this this elaborate ceremony? Let's remind ourselves, this process of mancipatio was the process by which these important forms of property, the res mancipi, were transferred. Now, in today's world, there are various forms of property that have special forms of transfer. Something like a book I can transfer under Australian English law simply by 2 things, delivery and intention. So if I hand my book and I say, here Aldo, this is yours, I intend to give it to you, and I deliver him the book, that's effective in law to transfer it. Not so for real property, at least in Australia. We have what's called the Torrens title system, and we have a register. And also there's a personal property securities register where people can register their personal where they can register security over personal property. Now the idea is not dissimilar. The purpose of the modern day register is to broadcast to everyone who owns this property. If I find a piece of property and I think it's deserted and I say to myself, oh, I might build a house here, I really want to know who owns it, or if anyone owns it, before I take those steps. In relation to a book or something, it's not as the consequences are not as dire if I get it wrong. Now the Romans didn't have a register, so they had another way of trying to publicise who owned what, and that's the purpose of the 5 witnesses. It's a way of making known who owns the property. Now, it's not fail-safe, of course. In a large society, perhaps 5 witnesses is not a great deal, but this was a form of property transfer that is antiquated and would have had quite high efficacy, or it would have been quite useful and effective in making known who owned what property if you had at least 5 witnesses to every property transfer. In the empire, it became the norm to document the mancipatio in a memorandum, and over time the memorandum itself became conclusive evidence of the mancipatio procedure. So people just bypass the procedure and use the document. But I think that's quite a nice, quaint, interesting procedure for the transfer of land. Okay, we only have a few more topics to go, 3 more topics to go, and then we'll revisit our scenario to see if we can apply any of our learning. I'm now going to say something about the Roman law of delicts. The heading to the introduction handout is "Help, my slave has committed a delict." What is a delict? In law, there are a number of events or reasons or justifications for imposing obligations on someone. The 2 broad categories in private law, so when you're just dealing with 2 private citizens, are agreement, or often manifesting as a contract. So if you say you enter into a mobile phone contract, you agree to pay your bill, and you have an obligation to pay your bill every month because you have agreed to do that. The prior agreement gives rise to the obligation. Now, the other broad category, in modern day we would call it tort. The Romans called it delict. These are obligations that arise not from prior agreement. If you're driving down the road tomorrow and you run over someone's leg, you may have an obligation to pay them damages for their medical bills. That obligation is imposed on you not because you didn't agree to this person to pay them damages, you'd never met them before. But the justification that the law has for imposing an obligation on you is because you've done something wrong. We call it tort in modern English law. The Romans called it delicts or delict. Now, there are other justifications for obligations in public law. There are statutes, for example, your obligation to pay your tax. You didn't agree to pay your tax and you haven't done anything wrong. But that's public law. That's an interaction between the citizen and the state. I'm talking about interaction between 2 private citizens. So the 2 main categories are contracts, obligations arising from prior agreement, and delicts. So this body of law dealing with obligations imposed on people in ancient Rome other than from prior agreement was called the law of delicts. There were many delicts. Some of the most famous delicts, or the ones that, if you took, say I took a course on Roman law of delicts at University of Oxford, we studied 4 delicts in particular. One of them was the delict called furtum, and furtum is another name for theft. So when we looked at the excerpt from the digest in the first half of tonight's talk, we were looking at the law of thefts. That's the English word for furtum. So that's one of the main delicts in Roman law, the Roman law of furtum. Another interesting delict is the delict of inuria. That deals with insult to personality. And that covers things like modern day defamation, but it's far broader. The Romans were a proud people, and if you insulted their citizenship, their personhood, their personality, there was a remedy given for that in Roman law, and it's actually inspired some debate in recent times in modern legal context, because the rights conferred under the Roman law of delicts are broader than, say, the modern law of defamation, and the Roman law of inuria would probably capture some forms of sexual harassment that in modern law fall through the cracks, where there's no real private law remedy. So it's quite interesting in law reform circles, people have been discussing and saying, well, maybe we should have something like the Roman law of inuria. One quite perhaps seemingly bizarre example, the Roman law of inuria would would capture conduct, including such as if you say interfered with a woman's chaperone, or you followed a woman home closely, you could fall foul of the delict of inuria, because you would be conveying the impression to other people that the woman that you were following was a woman of loose morals, either because she didn't have a chaperone who you had distracted on some mischievous false errands, so you could get the woman on her own, or even following a woman home could be at too close quarters could be actionable. So that's quite interesting, and it's quite a modern concept, in the sense that it might be an area where we think, yes, maybe we could learn something from a Roman law of inuria. There's a scholar in Melbourne University Law School who's the world leading expert on inuria. His name's Eric Dischmaker, and he has I don't have it here, but he has a textbook just on inuria. It's a fascinating delict. The other delict that is relevant for present purposes is the lex aquilia. And as you recall from part 1, lex aquilia, that's a law passed in the Republican period, and it was proposed by the magistrate Aquilia, which is where it takes its name, the law of Aquilia. Now, the lex aquilia had various parts to it called chapters. I've reproduced, the chapter's a funny name because it's only a small segment, but in the additional materials, if you have a look at the 3rd page, you'll see the glossary, an example formula, and then at the bottom of the page you'll see chapter 1 of the lex aquilia. That's an excerpt from the digest. You'll see D.9.2.2 under the heading chapter 1 of lex aquilia. That's a reference to the digest. So if you wanted to find in the digest, the D stands for digest. The first number takes you to the book. So you pick up the digest, you go to book 9, title 2, fragment 2, and PR stands for principium, just to make them complicated. That's the bit of text that appears right at the beginning. But let's have a read of this. Gaius tells us, if anyone kills unlawfully a slave or servant girl belonging to someone else, or a four-footed beast of the class of cattle, let him be condemned to pay the owner the highest value that the property had attained in the preceding year. Okay, so returning to our scenario, you'll recall that your slave Sticus has run over and killed Lucius. And Marcellus, who was Lucius's owner, is furious. Someone's going to have to pay up. And if someone brings an action on the lex aquilia, the damages, or the amount of money that will be paid, will be the highest value that the property had attained in the preceding year. It's not the value of the slave at the time of the slave's death. It's the highest value in the preceding year. Now, the thinking there seems to be that allowed for, or it cognized seasonal fluctuations in the price of slaves and cattle and so forth. The price might dip and fall over time, and the owner who had lost his slave, in this case Marcellus, the idea being that Marcellus should get the best of it, so Marcellus would get the highest price that the slave was worth. This concept is teased out in some of the legal texts by various examples. One of the most fun examples is if, say, let's say you have a slave who is an expert painter, and he happens to lose his hands in an accident, and then a week later he's run over and killed down at the market. You will receive his value assessed when he was an expert painter. So even though he's lost all his fingers and now he's worthless, you will still receive his value on the basis that he was the valuable valuable painter. Okay, so the lex aquilia is what we would what Marcellus would rely on to sue, because there has been a wrongful killing of a slave. And now we're coming to the final two topics. The final topic is how did you actually sue someone in the formulary system? There are various modes of civil procedure over the life of ancient Rome, and in AD 120, which is when our scenario is set, there was a particular system called the formulary system. We won't have time to hop into the detail, but the broad outline is this. To sue someone was a two-stage process. The first stage was the parties would go before the praetor, you recall was the administrator of the civil law, and there would be a discussion before the praetor as to what the case was about, what the issues were in play, and the praetor would issue you what's called a formula. It was a pattern that set out what needed to be decided on the facts of this particular case. So the formula for a case dealing with theft would be different from a formula dealing with a case on the lex aquilia, would be different from a formula, say, if someone had borrowed some money and they hadn't paid it back, an unpaid debt. Again, on the additional materials, just above where we were looking earlier, so we're on the additional materials on page 3. Under the glossary, you'll see the heading example formula. That's an example of a formula that the praetor would issue if there was some dispute around a payment of money. Now, I'll read that shortly, but before I do, I'll just explain what the second step was. After you receive the formula from the praetor, the parties would then go to the second stage, which was not before the praetor, which was before a lay judge called a iudex, I-U-D-E-X. And the iudex would have the formula, which had come from the praetor, and the formula would tell the iudex what needed to be resolved, and the iudex would be a judge of fact and law. The parties would be represented by advocates, there'd be evidence, there'd be speeches and so forth, and the iudex would act as the judge and decide the case. So the two-stage process. First step, obtaining the formula from the praetor. The second step, going before the iudex. The iudex was chosen from a list of eligible men who, as part of their service to Roman society, were willing to act as judges, but they were not trained lawyers. You might think that's a bit odd, having non-lawyers decide cases, but we do it today with juries. We have lay people making decisions, complicated decisions of fact, and finding people guilty or not. So the Romans used a iudex. Just having a look back at that formula on the page 3 of the additional materials, the formula came in a number of parts. The first was the nominatio, and that was the nomination of the iudex. So that's the praetor saying, let Titus be the judge. And then we have the meat of the formula. If it appears that Numerius should pay Julian 100 denarii, then if there is no agreement between the two that the sum should not be sued for, you, iudex, condemn Numerius to Julian for 100 denarii, otherwise absolve him. So if I was the iudex and that came to me, I would say to myself, oh great, the praetor has appointed me the iudex for this case. What do I need to decide? All right, I need to decide, does it appear that Numerius should pay Julian 100 denarii? So was there a loan? Was there a mistaken payment or some description? And the other thing I need to decide was there an agreement that the sum need not be paid for? So what's happening there is Numerius might be saying, yeah, sure, I borrowed the 100 denarii, but Julian said I didn't have to pay it back because I helped him out with his crops for the last month or something. So that's the very basic outline of the process of civil litigation. Now, the final topic is the concept of noxal liability and noxal surrender. And well done on everyone in hanging in there, because this is where it all gets tied neatly together and you say to yourself, my God, I'm glad I hung in there for the full 2 hours. So let's draw together some of our previous knowledge in light of the scenario. The scenario involves Stickus, one of your slaves, running over Lucius. Now, Marcellus can have resort to the lex aquilia. That provides a remedy where there's been an unlawful killing of a slave. But what's the problem if Marcellus tries to sue Stickus? Remember, Stickus is the chap who is driving his cart to the market. The problem is that Stickus is a slave and doesn't own any property. So there's no point in Marcellus suing Stickus. Usually when we sue people, we want money. And if we sue a slave who doesn't own anything, leaving aside the question of the peculium, which raises complications which I can touch on, but the starting proposition is that Stickus doesn't own any property. So there's no point in suing a slave. The Roman law came up with a device called noxal liability, where the master would be liable for the slave's wrongdoing. So the victim, in this case Marcellus, remember Lucius is just a slave, so he himself is just property. I mean, with all due respect to Lucius, he is a talented lyre player. He has died, but he is just a piece of property. The person who has actually suffered loss is Marcellus. Marcellus has suffered economic loss, the loss of the use of the slave. So Marcellus is the real victim here. He's the person we should be feeling sorry for. He can sue you for your slave's wrongdoing. Okay, so that's noxal liability. Now, what if you had a slave running around causing you deep distress, causing delicts everywhere and causing you immense financial harm? The Roman law had another solution to this problem. If you were sued for your slave's delict, you could either A, pay the damages, or B, you could surrender the slave. And that's called noxal surrender. So it's actually an early form of limited liability. It's quite fascinating. Today we will use corporations to limit our liability if we're carrying on a business. We don't want to have our personal assets at risk. We'll incorporate an entity and use that. Here you could have slaves running your business enterprises, and if they committed a delict, your liability would be capped at the value of those slaves, because if they committed delicts, you could just surrender them over. So the master had a choice to either pay up or noxally surrender. And here's the final necessary bit of information you need to unlock this puzzle. Noxal liability, the noxa, was the mischief, and that attached to the, you can think of it as attaching to the slave's head. If a slave committed a delict and was sold before the victim sued the original master, the noxal liability would follow the slave's head and would carry over and could be visited upon the new master. So one of the solutions to this problem is, if you know Marcellus is going to sue you, you could try to quickly sell your slave Stickus before Marcellus initiates proceedings against you. So that is another Another trick, so if you're down in the marketplace buying some more slaves tomorrow on your Sunday morning, you want to be careful that the slaves you're buying don't have any product defects, any latent defects, any Knoxall liabilities attached to them. So with all that knowledge in mind, let's just skim back over the scenario one last time, and I note the time, so we'll end here. The year is AD 120, the cusp of the High Classical period. When we see that phrase, we now know that's when the formulary system was in use and many of the legendary jurists were writing their works, their textbooks. One in particular we know, Gaius, AD 161 in the High Classical period. You're a wealthy land and slave owner. We've learnt about how to transfer land, being res mancipi, how to transfer that by mancipatio, and slave owner. We've learnt about the role of slaves and how they cannot own property themselves, subject to this curious concept of the peculium. You entrust Sticus, one of your most loyal slaves, to put part of your funds, a peculium, to work. And Sticus is eager to curry favour with you, and we've learnt that slaves can build up the peculium and even buy their own freedom. There's an accident. Sticus runs over and kills Lucius. Lucius too was a slave. Marcellus, who was the owner, is furious. So you know about the Lex Aquilia now. You know that there is a remedy for someone whose slave is killed. They could sue you on the Lex Aquilia, and you would be liable for the highest value of the slave in the preceding year. We've learned a bit about the two-stage process of litigation, one before the praetor and two before the iudex. And we finished by learning about this idea of Knoxall liability. So Marcellus can come after you, even though you weren't the one driving the cart, your slave was. And you have two options. You can, if you're found liable, you can pay up, or you can surrender Lucius, or before you're sued, you can try to sell Lucius down at the market, noting that the Knoxall liability will follow his head. So there you go. We have crammed in quite a lot in the last 2 hours, and I do hope that you've come away knowing a bit more about Roman law.
So, look, to you, Mr. Goodyear, we know you are very busy, and the fact that you took time out of your day to share your amazing knowledge with us is highly appreciated. The material is also very relevant to the theme of education we seek to provide and discuss in Nova Roma. It was interesting to hear about the sources of where we can obtain the history of Roman law, the grand role of Justinian on law history and his digest, and of course as well as the potential fate of Marcus and his slave Sticus. We hope that we can continue to do this again sometime and continue to work with you and those of the Roman Law Reading Group too. So on behalf of Nova Roma here in Australia and internationally, we'd like to extend our warmest thanks to you for presenting here today. So gratias tibiago Mike. And with that, we'll probably end the recording there and say bonum noctem. And I guess thank you to everybody else for your attendance here.